Hello friends, I am Tanisha Gangrade and you are watching TG Agri. Friends, today we will discuss about intellectual property rights, that is IPR, and its laws in India. Okay. Next, we will discuss about that what is intellectual property, why it is so important, and what are its rights that we are called as intellectual property rights. Then we will discuss about what are its objectives, history of IPR in India, trade secret, trademark, industrial design, patent, copyright, plant variety protection, and the last is geographical indication, that is GI tag. Okay, so in this video we'll study about all of these topics, friends. So please watch this video until the end. So let's begin with this video. Intellectual property. Okay, before we can discuss intellectual property rights, we must first define that what exactly intellectual property is. Only then we can discuss its rights. Okay, so we are all aware that we have two kinds of property. First is physical property and the second one is intellectual property. Okay, first we will discuss about the physical property, then we will discuss about intellectual property. Okay, so what is physical property? We are all know that these are the properties that we can feel or touch. It can be of anything. It can be a land, it can be money, gold, or any other type of property. But what exactly intellectual property is? It can be referred as a mental creation. It can be anything. It can be a design, it can be an invention, an idea, a manuscript, okay, which eventually results in a useful product. We have different laws to protect our physical property. Similarly, we need laws to protect our intellectual property so that no one else can get benefit from it. So these rights of an inventor to protect its intellectual property is known as intellectual property rights. Okay, so I hope you understand that what intellectual property is. Okay, now we will go ahead and here it is what intellectual property right. Okay, what are the definition? Rights of an inventor to derive economic benefit from his intellectual property. This right is called as intellectual property rights, as I told you. Okay, now we will discuss about objectives of granting IPR. First one is it helps in protecting the ownership and originality of the individual's creation. Obviously, the owner of the intellectual property can use or sell their product. No one else can sell others' product by giving our name. Obviously, concerned person will get recognition. It provides financial benefits to concerned authority or product because it creates a monopoly for their product. Okay, now next is it motivate others to create their own intellectual property. It improves both the individual financial situations and the economy of our countries, to raise the institutions performance level, to encourage researchers and institute to compete for research quality. These were the objectives of intellectual property. Okay, now we will study about history of intellectual property rights. The first law on patent was passed in Venice in 1474, which gave monopoly rights to artisans for their inventions. As we studied the same thing in the objectives of IPR, that intellectual property provides monopoly rights. Okay, so here it is in 1474, the law of patent was passed, which provides monopoly rights to artisans for their inventions. Now we will talk about the legislations covering IPR in India. The first one is patent, and we are aware about this. The Patent Act was passed in 1970 and it was amended in 1999, 2002, 2003, 2005, and the latest amendment was done in 2006. Okay, if question will ask about the latest amendment, then you have to choose it was amended in 2006. Okay, next is design. Earlier design act was passed in 1911 and the new design act was passed in 2000. Okay, now we will discuss about trademark. The first one is earlier Trade and Merchandise Mark Act was passed in 1958 and the new Trademark Act came in 1999, which was enforced in September 15, 2003. Okay, friends, you must remember the year of the act and its amendment year. Okay, the next is copyright. The Copyright Act passed in 1957, amended in 1983, 84, 92, 94 and 99, and the copyright rule was passed in 1958. There was a lot of confusion between the year of the act and the year of the rule. So we know that a come first in the alphabet, so act came first, then rule. Okay, act in 1957, rule in 1958. The next one is protection of undisclosed information. It covered under the Contract Act 1872. Next is geographical indication, that is GI Act was passed in 1999. Next is protection of plant varieties and farmers rights act, which was passed in 2001, which is based on sui generis system. What is sui generis system, we'll discuss it later. Next is the National Biodiversity Act passed in 2002. Okay, so these all are legislations covering IPR in India. Now we will discuss each laws in details. Okay, the first one is trade secret. Okay, before discussing in detail, we will look out the term trade secret, or we will look out the term secret. What does the term secret mean? Secret means something which is not known to other people. Similarly, in this case, the owner of intellectual property does not reveal or does not disclose its information and keep it as hidden. So these type of property rights is known as trade secret. The best example of trade secret is Coca-Cola. Until today, the Coca-Cola company does not reveal their formulation or keep it as a secret. Okay, their secret ingredient of Coca-Cola company known as merchandise 7X, and it was asked in NFL exam, what are the secret ingredient of Coca-Cola company? So it is known by merchandise 7X. John Pemberton keep it as a secret since its invention in 1886. Remember this date. Who has done it? John Pemberton. When? In 1886. Okay, so if question were asked that it is related to what are other things, so it is related to formula, processes, or any other kind of material. Okay, now we will talk about advantages of trade secret. Okay, the first one is they are for unlimited duration. As we have seen earlier that John Pemberton took trade secret since 1886, so it is for unlimited duration. There are no time boundaries. Okay, the second one, it is not necessary to satisfy the rather stringent requirement for protection under patent. The third one is the cost of filing, contesting and enforcing patent is saved. Okay, if we will talk about patent, okay, so there are time limits in case of patent. We have to renew our patent in every 10 to 20 years, which take a lot of time and money. But because there is no time limit in trade secret, our filing costs are reduced. Okay, we keep our intellectual property confidential, so there is no way to improve the product or process. So these are the advantages of trade secret. Now we will discuss about what are the drawbacks of trade secret. Okay, the first one is maintaining a trade secret itself a costly affair. How and why it is so? So let's see. First, we will talk about an example of Coca-Cola company. Many people work for Coca-Cola company, and some of them are aware of their secret ingredient. They may reveal it to others. This is why keeping it as a secret is an expensive affair. The second is it does not provide any protection from anyone's independent innovation. Okay, the third one is it does not allow anyone to improve their original invention. It remains the same year after year. And the last one is it cannot be applied to many inventions, for example equipment designs, plant varieties and books. So these are the drawbacks of trade secret. Okay, the next one is trademark. Now we will discuss about trademark or these kind of right. So before discussing these, we will cut this term into two different terms. The first one is trade and the second one is mark. So what do you mean by mark? Mark means any kind of sign which represent anything. Here it is trademark. Trademark means any kind of sign which represent your trade is known as trademark. If we will talk about its symbol, then it is written under bracket in which capital TM is written on the top of the bracket. Now we will talk about its definition. What it is? It is the mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others. As we all know that each company has their own trademark which represent their goods graphically. We can identify that particular company by just seeing their trademark. So question is, what are the requirements of trademark? How it is made? So there are three main requirements of trademark. What are they? It should be descriptive, it should be distinctive, and the third one is it should be generic. Without these three requirement, our trademark is incomplete. Now question is, what it includes? It includes shape of goods, their packaging and combination of colors. Now we will see that it also includes device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging or combinations of color or any such combinations. So I hope you understand that what are the main objective of trademark. It helps in the differentiation of goods from one person to the next or from one industry to the next. So here we discussed trademark. Now we will discuss about industrial design. What do you mean by industrial design? And what are the rights called industrial design rights? Before understanding these, we will take an example so that you can easily understood this. Suppose you went to a jewelry shop and there are lots of designs within the same range and same quality, but you choose the one which is the most attractive among all, and that particular design belongs to only one of the jewelry shop. It may be Anand Jewelers, it may be a Punjab Jewelers. So that one particular design will be an intellectual property for these shop and it needs to be protected so that no one else can use their design. So the rights to protect their industrial design is known as industrial design rights. It is applied to wide variety of industrial products and handmade goods such as cars, telephones, computers, packaging and containers, technical and medical instruments, watches, jewelry, electrical appliances, textile designs and many other types of goods. But our question is, what designs can be protected? Is everything can be protected or is every designs can be protected? No, only ornamental designs can be protected. And the next important point is, what should be the feature of industrial design? In three-dimensional feature, it may be a shape, surface of an article, and in two-dimensional feature, it is a patterns, lines or colors. So these are the designs which can be protected. Okay, now we will talk about the industrial design rights. As I told you, the right which protect the industrial design is known as industrial design right. Only the right holder has the rights to use their design for commercial production, importation and sales of products with the protected designs. Industrial design rights are only valid for limited time. It varies from country to country, but maximum period of protection in a country will be at least 10 years. It can be renewed after every 10 to 20 years. Okay, so here we discuss now industrial design. The next one is patent, and we all know that patent is one of the most important intellectual property right. So before discussing it, we will look for its introduction. Patent word taken from a Latin language word pater, which means to lay open or to make it available for public inspection. Okay, but Here question is, what do you mean by patent? So patent is the right granted by government to an inventor so that no one else can use their invention without their permission. They need to take their permission, then only they can use their invention. Here question is, patents are granted for what? So it is granted for an invention, innovation, improvement in an invention, process, product of an invention, and the next one is a concept. Here are some requirements of patents. What are they? It should be novel, inventiveness, it has some industrial application and usefulness, it has some patentability, and the last one is disclosure. One by one we will discuss this term. Okay, so first one is novelty. What do you mean by novelty? Your invention should be novel and unknown to the public. The second one is inventiveness. It Inventiveness means it should not be obvious to a person. So what do you mean by obviousness and non obviousness? Just take example so that you can easily understand it. Take a glass of water and add some salt. So what it results? It results in salty water. So it is a very known phenomenon that if you add some salt in water, then it results in salty water. It is very obvious and everyone known this phenomenon. So your invention should not be obvious to a person. The next is, it has some industrial application. The next one is patentability. What do you mean by patentability? It means your invention will be patented if it follows all the eligibility criteria of Indian Patent Act 1970 and its amendment. If it fails to follow rules and norms, then your application will be rejected. The next one is disclosure. It means the inventor is required to describe his invention in sufficient details so that a person of a normal skill is able to reproduce it. Now the property which cannot be protected, so it is a scientific principle or an abstract theory, a discovery of new property or new use for known substance, a method of agriculture or horticulture, or an invention relating to atomic energies are not patentable. Here is a famous example of patent. As we all know that basmati rice originates from India and Pakistan, but Rice Tech Texas company took its patent on September 2, 1997. These claims were challenged by India for re-examination of patent was filed on April 28, 2000. And the last is limitation of patent. So there are two basic limitation: limitation of time and limitation of space. Patent is valid only for 15 to 20 years, and if we talk about the limitation of space, so it is valid only the country in which it is awarded, not in other countries. So here we talk about limitations of patent. The next one is copyright. Now we will see that what do you mean by copyright and what are the things which can be prevented by copyright. See, copyright is mainly a right to an author or an artistic worker so that no one else can sell their work by giving our name. For an example, here is a book, Fundamentals of Plant Breeding. It is written by B.D. Singh. Okay, he took copyright of these fundamentals of plant breeding. What does it mean? It means that he only has right to sell this book or to change its information. No one else can sell this book by giving our name. Okay, but here is one condition: it does not prevent another person from using either the idea or the information. It means you can use their idea or you can use their information contained in the copyright material. It only prevented or it only protected from the reproduction of that particular copyright material, but it cannot prevent or protect their ideas or the information contained in it. You can use their information. If we talk about the duration or terms of copyright here, so in case of original literary, dramatic, musical and artistic work, the duration of copyright is lifetime and 60 years following the death of the author. See, so if you asked about the duration, so it is lifetime of the author. Okay, now we will talk about the things which can be protected by copyright. So it is literary or dramatic work, a musical work, an artistic work, cinematograph, film, a sound recording, a photograph and a computer generated work. So here we talked about copyright. Now we will talk about plant variety protection. What do you mean by plant variety protection? Is there any special kind of variety which can be protected, or every variety can be protected? We all know that formation of a new plant variety is really a very skillful and hard work. The variety which is formed by any plant breeder is intellectual property for them, and it needs to be protected. This is why USA follow three different systems to protect the plant variety. The first one is Plant Patent Act 1930, which covers mostly asexual propagated crops, example ornamental and fruit trees. The second one is the Plant Variety Protection Act of 1970. India followed this law and renamed as PPVFR Act, which is known as Plant Variety Protection and Farmers' Rights Act 2001. And the third one is the Utility Patent Act 1985, which was originally meant to cover man-made industrial inventions and processes. This comes under plant variety protection. So the last topic of this video is geographical indication, that is GI. What do you mean by geographical indication? By just seeing this term we can easily conclude its meaning. Geographical indication, it means when a geography of a particular place indicates the goods of that particular place is known as geographical indication. Here it is also written that it is a sign used on a product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. Now we will talk about that what it includes or what it covers. So it covers agricultural goods, natural products, manufactured products, goods of handicraft, and even food product. But here condition, it is not applied to intellectual property. Why? Because geography of a particular place is not intellectual property, it is a natural property, or it is a nature. Okay, and the next we will talk about its act. So here it is Geographical Indication of Goods Act, which is passed in 1999 and enforced in 15th September 2003. If we will talk about the first GI Act or GI tag was given to Darjeeling tea in 2004 and 5, and there are so many other products which represent their geography. For example, Bikaneri Bhujia from Rajasthan, Banarsi brocades and saris become GI tagged up to September 2010. Now we will talk about the duration of GI tag. So it is valid only for 10 years, and we have to renew our GI Act after every 10 years. So friends, in this video we talked about the main laws or legislations covering IPR in India. So friends, I hope you easily understood this topic, but still if there is any doubt or queries, you can ask me in the comment section, as well as you can follow our Instagram page and Facebook page. Link has already given in the description. You can also join our Telegram channel and WhatsApp. Link is given in the description. We will stop this video here, but before that, stay healthy and stay happy. Thank you.